Good evening. I'm Marcy Kahn, Chair of the New York City Bar Association's Task Force on the Rule of Law, and I welcome you to the launch of our four-part series this spring on New Frontiers in Federalism. This series is intended to take a hard look at how recent Supreme Court decisions like Dobbs, Bruin, and West Virginia versus EPA, as well as state legislative changes, are challenging our understanding of federalism in terms of relations among the states and between the states and the federal government. Over the course of the next several weeks, we will examine the new federalism landscape for judicial, legislative, and administrative agency action through discussion of the issues of reproductive rights, corporate conduct, climate change mitigation regulation, and gun safety legislation, and will ponder the future of nationwide responses to these issues that bear so closely on the lives of ordinary Americans. Our series leadoff program this evening is entitled The Changing Tides of Federalism. We have a stellar group of scholars to address us this evening who will drill down into the concept of federalism historically and examine its transformation in the current legal environment, where we have seen direct clashes among governments and conflicts between governmental authority and popular sovereignty, now affecting millions of citizens. I offer the thanks of the Rule of Law Task Force to the Birnbaum Women's Leadership Network and the Brennan Center for Justice, both at NYU Law School, as well as to the 6 other City Bar committees for co-sponsoring this evening's program. And my thanks to our series program chair, Bob Cusimano, for conceiving of this timely series of programs, and to Professor Jennifer Rodgers, our series co-chair, who will also be our moderator tonight. Before we get underway, I want to explain the format for tonight's virtual discussion on Zoom. All members of the audience will be muted during the program. The Zoom chat function is disabled for audience members, but you can type your questions into the Q&A function by clicking the tab at the bottom of your screen. We encourage you to do that as we go through the program, and we will try to get to as many of your questions as time permits after we've heard from all of our speakers. Our moderator for this evening's program, as I've said, is Task Force member Jennifer Rodgers, who serves as adjunct professor of clinical law at NYU Law School, lecturer in law at Columbia Law School, and legal analyst for CNN. She has chaired the Bar Association's annual Supreme Court Review Symposium and is a leading member of the Task Force on the Rule of Law. Professor Rodgers will be introducing our speakers, all of whom will be glad to take your questions at the conclusion of all of the presentations. Professor Rodgers, the floor is yours.
Thank you, Marcy, for that introduction and for your excellent leadership of the Rule of Law Task Force. And thanks to the City Bar folks who are supporting the webinar tonight, the tech folks and all the others who've helped make this program a reality. So good evening and welcome, everyone. Thanks for joining us for what I know will be a fascinating and important conversation about federalism and how it impacts us today. Tonight, we start with the first in our 4-part series, and we have 3 eminent speakers to help us make sense of all of this and to set the table for the next 3 events as well. I'm going to give very, very brief introductions to them and what they'll discuss, because as you might imagine, each of them has an impressive CV about a mile long. So for more information on their scholarship and publications, please see their web pages at their relevant institutions. First, we will start with Dean Erwin Chemerinsky of the UC Berkeley School of Law. Dean Chemerinsky, a renowned constitutional scholar and appellate practitioner, will take us through the background and history of federalism, some of the particular challenges that have recently emerged, and his sense of where we're headed. Our next speaker, Professor Bertrell Ross of the University of Virginia Law School, whose scholarly focus includes constitutional law and theory and election law, will drill down on what is happening with federalism in the civil rights context, with a specific emphasis on voting rights, an area of incredible importance to our democracy that is the subject of increasing numbers of court cases and legislative actions that puts these rights in significant jeopardy. Finally, Professor Julie Suk of Fordham Law will talk to us about reproductive rights in the post-Dobbs era. Professor Sook, whose many areas of expertise include anti-discrimination law and gender and sexuality law, will lay out the major ways in which federalism is implicated as access to surgical and medication abortion, and necessarily access to other aspects of reproductive care as well, are being legislated away by states, leading to dozens of court challenges all over the country. After our speakers are done, we will take questions, as Marcy said. So as you think of something you'd like to ask, please drop it in the Q&A function on the platform. There's no need to wait till everyone's done speaking. Go ahead and put them in as you think of them, and we'll get to as many of those as we can. In the meantime, I will turn it over to Dean Chemerinsky. Please take it away.
Thank you so much for the kind introduction. It's such an honor and a pleasure to be part of this series, and it's wonderful to get to do this with Bertrand and Julie. Debates about federalism are as old as the country, and they will continue as long as the United States exists. What I mean by federalism is simply the division of power between the national government and state governments. Some of the most important political fights in history have been done in the name of federalism. Often it has been the use of federalism to try to oppose progressive change. In the early 19th century, those who opposed the abolition of slavery did so in the name of states' rights and federalism. Most famously, John Calhoun, a senator, argued that states are sovereign and could interpose their sovereignty between the federal government and the people and stop the national government from abolishing the institution of slavery. Reconstruction was opposed very much in the name of states' rights. Between the 1890s and 1937, the Supreme Court struck down many federal laws, progressive laws, in the name of states' rights. When Congress adopted the first law prohibiting child labor, outlawing the ship and interstate commerce of goods made by child labor, the Supreme Court struck it down on federalism grounds. In the 1950s and in the 1960s, the opposition to desegregation was often phrased in terms of states' rights. You saw Southern governors like Orville Faubus in Arkansas picking up the rhetoric of John Calhoun about the authority of states to interpose their sovereignty between the national government and the people. In Ronald Reagan's first inaugural address in 1981, he proclaimed a new federalism as a basis for dismantling federal social welfare programs and turning things back to the states. And yet it would be a mistake to think that federalism is just something that conservatives use, especially at this moment in time. We see liberals latching on to the idea of federalism as a way of advancing civil rights and civil liberties. In 1977, then Justice William Brennan wrote an article in the Harvard Law Review imploring state courts to use state constitutions to expand rights and liberty. Brennan was writing in response to a court that had become profoundly more conservative after President Richard Nixon appointed 4 justices, a court, though, that is far less conservative than we have today. And Brennan thought it would be important as an alternative to the Supreme Court in the United States Constitution to have state courts using state constitutions. Today, this is more important than ever. When we talk about the abortion issue, it's been left by the Supreme Court to the states into the political process. Many states protect privacy rights and abortion rights under their state constitutions. It is important to draw a distinction. When the United States Supreme Court says that there's no federal constitutional right, then it is left to state courts and state constitutions. That's what's happened with regard to abortion. On the other hand, if the Supreme Court says there is a federal constitutional right, then the authority of states is inherently limited. So when the Supreme Court says that the Second Amendment broadly protects gun rights or equal protection outlaws affirmative action, so I think the court is about to do, then there's much less latitude of states to act. My point in this introduction is simply to say that federalism has been enormously important through American history, and it continues to be quite significant. There are underlying issues in this regard. How much should we care about protecting states as states? Some believe that states are an important check against tyranny of the federal government. The dividing power vertically between the federal government and the states can prevent tyranny, just like dividing power horizontally among the branches of the federal government and separation of powers accomplishes. Some believe that we should devolve more power to the states because they're closer to the people. It's been argued throughout American history that it's good to leave things to the states because states are laboratories for experimentation. And yet each of these arguments is challenged and criticized, especially by those who believe we need national power to protect rights all over the country, to advance what's good for a country at a time of very complex economy. And so the argument is that the protection of states' rights doesn't do anything to prevent tyranny or enhance democracy. And there are areas we don't want states to be laboratories of experimentation. There's an underlying issue of how much do we want to protect diversity in letting state governments make choices, or how much do we prefer uniformity, but some of the things we really care about? We don't want states to be able to make the choices. What do we really want to be national? And what do we want to be local? That's what we're talking about when we focus on federalism. I was asked in this introduction to focus on the areas of federalism that have arisen historically and that continue to come up. I want to talk about three. One is federalism is a limit on congressional power. The second is federalism is a limit on state and local government power. And the third is federalism is a limit on the federal judicial power. Each has been historically important. Each is likely to be very important in the years to come. To elaborate, let me go back to the first area. Federalism is a limit on congressional power. As I've already alluded to, there's an underlying question. How broadly should we define Congress's powers to deal with the social problems, the complex economy of the 21st century? Or how much should we limit Congress's powers so as to leave more governance to the states? The Supreme Court has not been consistent in answering these questions. Quite the contrary, over the course of American history, it's been a pendulum swinging back and forth. For the first century of American history, from 1787 until the mid-1890s, the Supreme Court took a broad view in interpreting the scope of Congress's powers. The court rejected the idea that there's a zone of activities left to the states for their exclusive control. From 1787 to the 1890s, not one federal law got struck down as exceeding the scope of Congress's power. Not one federal law got struck down as infringing a zone of activities left to the states, such as by the 10th Amendment. But then from the 1890s to 1936, there was a court that very much limited the scope of Congress's power. There's a court that aggressively used the 10th Amendment and states' rights as an independent constraint on federal authority. The Supreme Court narrowly defined the scope of Congress's power to regulate commerce among the states. The Supreme Court said, during this era, that Congress's power to regulate commerce extends to only one phase of business, buying and selling, that Congress couldn't regulate production, mining, manufacture, or the like. So when there was an effort to apply the Sherman antitrust law to a monopoly in the sugar beet industry, the court said, this is about production, not commerce. It exceeds the scope of Congress's power. When Congress tried to regulate production in, say, coal mines or poultry farms, the Supreme Court said, no, this is Congress trying to control production. Congress can't do that under the Commerce Clause. Likewise, the Supreme Court said during this era that even if Congress was regulating commerce among the states, or even if Congress was taxing and spending for the general welfare, Congress could not try to control production. I alluded in my introduction to a very important case about child labor. It's often called the child labor cases, Hammer versus Degenhardt, where the Supreme Court struck down a federal law that prohibited the shipment of interstate commerce of goods made by child labor. The court said that intruded on a zone of activities left to the states. When Congress tried to create the first agricultural price support program, the Supreme Court struck it down, saying it was trying to control production. This was a time of a very conservative court, a very pro-business court, committed to an unregulated laissez-faire economy. And one way it manifested itself was in the limits on Congress's power. But then, after 1937, the pendulum swung in the opposite direction. From 1937 until 1995, not one federal law was declared unconstitutional as exceeding the scope of Congress's Commerce Clause power. From 1937 to 1992, there's only one case where the Supreme Court found something to violate the 10th Amendment, and that case was overruled 9 years later. The Supreme Court's view was that it's important to empower Congress to deal with national problems, that states as states are adequately protected through the national political process. The courts didn't need to do so. But in the 1990s, the pendulum swung back, and the Supreme Court once more started limiting the scope of Congress's commerce power. The Supreme Court again took the view that there's a zone of activities reserved to the states for the exclusive control. So, for example, in United States versus Lopez in 1995, the Supreme Court declared unconstitutional the Federal Gun-Free School Zone Act, federal law that made it a federal crime to have a gun within 1,000 feet of the school. The Supreme Court saying that this exceeded the scope of Congress' authority to regulate commerce among the states. 5 years later, in 2000, in United States versus Morrison, the Supreme Court struck down the civil damages provision of the Violence Against Women Act. The provision allowed victims of gender-based violence to sue. Congress based this on a finding that violence against women cost the American economy billions of dollars a year, and that state courts were not receptive to such claims. Nonetheless, the Supreme Court declared this unconstitutional. At the same time, the Supreme Court limited Congress's powers under Section 5 of the 14th Amendment. I think that the 14th Amendment, along with the 13th and the 15th, adopted after the Civil War, dramatically were meant to change the relationship of the national government and the states. Section 5 of the 14th Amendment gives Congress the power to enforce the 14th Amendment by appropriate legislation. But the Supreme Court reaffirmed that Congress under Section 5 can't regulate private conduct. It can regulate only state and local government activity. And Congress said that Congress under Section 5 is limited to laws that remedy or prevent violation of rights already recognized by the Supreme Court. The Supreme Court said Congress can't use this power to create new rights or expand rights. Why did this happen? And why, at least for now, is it largely stopped? I think it happened because of the change in the composition of the court. When Ronald Reagan appointed Sandra Day O'Connor, Antonin Scalia, and Anthony Kennedy, and then the first President Bush appointed Clarence Thomas, along with William Rehnquist, they were a majority to protect states' rights. And virtually all the cases I alluded to here were 5-4 decisions. However, the court seems to have, after the Rehnquist court, been less aggressive in regard to enforcing federalism. Not totally. Another aspect of the Rehnquist court's federalism was the use of the 10th Amendment in protecting the zone of activities of the states. In New York versus the United States in 1992, the Supreme Court said Congress can't force states to adopt laws or enforce federal programs. There, the court declared unconstitutional the Federal Low-Level Radioactive Waste Disposal Act that required the states clean up their nuclear waste by 1996, or even take title of them. In Prince versus the United States in 1997, the court struck down part of the Brady Handgun Control Act that required that state and local law enforcement personnel do background checks for issuing permits for firearms. And more recently, in National Federation of Business for Sebelius in 2012, the court said Congress could not force states to expand their Medicaid coverage on penalty of losing all their Medicaid funding that had violated states' rights. As I look forward, knowing it's a very conservative court, I would not be surprised to see the Supreme Court go back to limiting Congress's powers, go back to more aggressively enforcing the 10th Amendment as a limit on states. We might see this in the area of environmental law. We might see this in the area of business regulation. We might see it in the area of civil rights law. So that's one way that federalism has come up historically. Federalism is a limit on congressional power. A second way that federalism comes up is a way of empowering, but also limiting state governments. There's ways in which federalism is very much about empowering what states can do. The most obvious concerns the police power. State and local governments have the police power. It's their authority to do anything that's not prohibited by the Constitution. For Congress to act, it has to point to authority in the Constitution. It meant to say then that state and local governments do have the authority to do anything that's not constitutionally prohibited, whereas Congress needs to have congressional authority bestowed by the Constitution in order to act. This idea that states are empowered by federalism is reflected in the notion that states always can provide more rights than the United States Constitution is interpreted by the Supreme Court. They just can't protect less. An easy example, the Supreme Court said under the First Amendment, there's no right to use privately owned shopping centers for speech purposes. But the California Supreme Court said under the California Constitution, there is a right to use privately owned shopping centers for speech purposes. And the Supreme Court upheld that as constitutional. Or to go back to the issue of abortion, the Supreme Court has said there's no right to abortion under the United States Constitution. That was the holding of Dobbs versus Jacksonville Health Organization last June 24th. But states certainly can protect rights to abortion under their own constitutions, and many do so. But there's also a way in which federalism is a limit on what state and local governments can do. I'll give a few examples. The application of the Bill of Rights to the states. As originally thought of, the Bill of Rights was just a constraint on what the federal government could do. Indeed, the Supreme Court in the 1830s said it was obvious that the Bill of Rights was meant just to constrain the federal government. And so it wasn't until 1932 that the Supreme Court first said that the right to counsel under the Sixth Amendment applies in state court in capital cases with this possible death sentence. It wasn't until 1963 in Gideon versus Wainwright that the Supreme Court said that the Sixth Amendment right to counsel applies in state court in any case with a possible prison sentence. It wasn't until 1925 that the First Amendment freedom of speech was first applied to state and local governments. It wasn't until 1940 that free exercise of religion was first applied to state governments. And for most of the provisions of the Bill of Rights to criminal suspects and criminal defendants, it wasn't until the 1960s they're applied to state and local governments. There was an intense debate in the 1930s and 40s as whether the Bill of Rights should apply to state and local governments. At this point, except for a few provisions, it's clearly established that the Bill of Rights apply not just to the federal government, but state and local governments. The Supreme Court hasn't yet ruled about this for the Third Amendment, right to enter a soldier's court in a person's home. The court's never found that the Fifth Amendment right to grand jury indictment in criminal cases applies to state and local governments. And also the Supreme Court's never held that the Seventh Amendment right to jury trial in civil cases applies to state and local governments. But all the rest of the Bill of Rights apply to state and local governments as well as the federal government. And that's a significant constraint on what state and local governments can do. Another important constraint on what state and local governments can do comes from the doctrine of preemption. Simply put, if there's a conflict between federal law on the one hand and state or local law on the other, federal law wins out. The state or local law is struck down. In part, this is derived from a provision in Article 6 of the Constitution, the Supremacy Clause, that says that the Constitution and laws and treaties made pursuant to it are the supreme law of the land. There is an elaborate body of law dealing with preemption. It touches almost every area of law. And the Supreme Court has said that there can be express preemption Anytime Congress has the authority to act, in the text of a law can declare that federal law is exclusive. The federal statute says that federal law is exclusive, then state and local law is preempted. That's express preemption. Even in the absence of express preemption, there can be implied preemption. If a federal and state law are mutually exclusive, the state law is preempted. Or if the state or local law interferes with achieving a federal objective, there's preemption. Or it's an area where Congress has evidenced desire that federal law wholly occupy a field, there's preemption. All of these types of preemption get litigated every day in so many different areas. As I look ahead, I think we're going to continue to see a great deal of litigation with regard to immigration law. When does federal immigration law and policy preempt what states can do? When the Trump administration tried to say that state and local governments had to cooperate with ICE in deportation, they claimed that they were so-called sanctuaries and that the federal government could not commandeer them. Now, of course, there's challenges from conservative states to some of the Biden administration immigration policies. But preemption is an important area where federalism and issues over states' rights play out. One more example of federalism as a limit on what states can do is the principle called the Dormant Commerce Clause. The Dormant Commerce Clause says that it's unconstitutional for a state or local government to place an excessive burden on interstate commerce. It's been thought that one of the inspirations for the Constitutional Convention back in 1787 was the way in which the states were discriminating against goods from other states. There's no provision in the Constitution that says that states cannot place an undue burden on interstate commerce, but the Supreme Court has inferred it from the grant of power to Congress to regulate commerce among the states. And there's here too an elaborate body of law, but again, to show you how it's being litigated now, I can refer to a Supreme Court case argued this past October that awaits for decision. It's National Pork Producers versus Ross. California adopted a law that said that the only pork that can be sold in California is where the pigs were humanely treated. Most pork comes from outside California into the state. Much is produced in Iowa. The National Pork Producers said that the California law violates the Dormant Commerce Clause. On the one hand, there's the argument that says California's law is not discriminatory. It applies to all pork, whether produced in the state or out of state. And if a law is not discriminatory, it's only going to be struck down if its burdens on interstate commerce clearly exceed its benefits. On the other hand, the pork producers are saying one state shouldn't be able to regulate in an extraterritorial manner. A state should not be able to regulate what's going on with other states. And that's what California is doing. It's regulating what's going on in Iowa. California says, we're just regulating what's sold in California. But the pork producers are saying this is unconstitutional extraterritorial regulation. Depending on what the Supreme Court does, this could apply to so many state laws that regulate in a way that might be seen as having an extraterritorial effect. So as I think about federalism as a limit on what the states can do, I think of incorporation, I think of preemption, I think of the Dormant Commerce Clause. There's a third major area where I want to talk about, and that's federalism as a limit on federal court power. Let me again give some examples of ways in which concern for states' rights have been taken to limit what the federal government and federal courts can do. I'll start with sovereign immunity. The 11th Amendment says that the judicial power of the United States should not extend to suits against the state by citizens of other states or citizens of foreign countries. In 1890, in Hans versus Louisiana, the Supreme Court said that the 11th Amendment also bars a state from being sued in federal court by its own citizens. So it doesn't matter whether it's a suit for money or a suit for injunction. Doesn't matter whether it is a resident of that state suing the state or residents of other states suing the state. The Supreme Court has said that the 11th Amendment and sovereign immunity bar suit. The result is there's often people who are injured who have no forum when they can sue. There's a Supreme Court case of 1999, Alden versus Maine. It involved probation officers in the state of Maine who claimed that they were owed overtime pay by the state under the Federal Fair Labor Standards Act. They sued the state in federal court, but the Supreme Court said 11th Amendment can't sue a state in federal court. So they then sued in state court, but the Supreme Court ruled 5-4 that state governments can't be sued in state court either because of this principle of sovereign immunity. The probation officers had a federal statutory right to the money, but there was no forum, federal or state, where they could sue. Why not? Because of this concern about states' rights and federalism that was animating the conservative majority of the court. The Supreme Court has been very aggressive over the last several decades in expanding the scope of state sovereign immunity, limiting the ability to sue states. There are some narrow ways to get around the 11th Amendment. State officers can be sued for injunctive relief even when the state government can't. Congress, acting under Section 5 of the 14th Amendment, can override state sovereign immunity. But overall, the 11th Amendment and sovereign immunity are an enormously significant constraint on federal judicial power, all in the name of federalism. We're to pick another example that comes from the election law area that Bertrand is going to talk about, and that concerns the political question doctrine. And here I want to mention a Supreme Court case from just a few years ago, Rucho versus Common Cause. A little bit of background. In the 1940s, the Supreme Court said there could not be challenges to partisan gerrymandering as violating a provision of the 14th Amendment, known as the Republican Form of Government Clause. The Supreme Court said there's no judicial standards for determining when a state or local government and its election districts so malapportioned as to violate the Constitution. In many states were terribly malapportioned. Legislators who benefit from malapportionment weren't about to vote themselves out of office. But in Baker versus Carr, the Supreme Court said, if there's challenges to malapportionment as violating equal protection, federal courts can't hear them. And then in cases like Reynolds versus Sims, the Supreme Court said that it's a principle of one person, one vote. For any elected body with districts, all districts about the same in population. Here, the court chose the value of national uniformity in protecting the Constitution over a claim of states' rights. But in Rucho versus Common Cause, in 2019, the court came to the opposite conclusion. This involved partisan gerrymandering. That, of course, is the practice where the political party that controls the legislature draws election districts to maximize seats for that party. Partisan gerrymandering has always existed, but because of successful, sophisticated computer programs, it's possible to engage in it with far more precision than ever before. Rucho came from North Carolina, purple state, went for Obama in 2008, Romney in 2012, Trump in the last two presidential elections, but always by a close margin. In 2020, Trump beat Biden by 1.35%. The Republican North Carolina legislature ran 3,000 different possible maps to try to see which would give Republicans the most chance of winning 10 of 13 seats from North Carolina in the House of Representatives. It worked. In 2018, for example, using those maps, Democrats and Republicans got the same number of votes statewide, but Republicans won 10 of 13 seats. But the United States Supreme Court said federal courts cannot hear challenges to partisan gerrymandering. Doesn't matter how extreme or egregious. The court says there's not sufficient judicially manageable standards. It's therefore left to the states. Or one more example where federalism is a limit on federal court power, and that concerns habeas corpus. The writ of habeas corpus comes to American law from England. It was called the Great Writ. And the Warren Court significantly expanded the ability of federal courts to grant habeas corpus to those who are held, it claimed, in violation of the constitutional laws of the United States. The Burger Court and the Rehnquist Court very much limited habeas corpus And they did so explicitly in the name of states' rights. And then Congress in 1996 adopted the Anti-Terrorism and Effective Death Penalty Act that further limited the ability of federal courts to give relief to those who claim they're held in violation of the Constitution and the laws of the United States. It's now very difficult to have a federal court hear a habeas petition, and even more difficult for a federal court to grant a habeas corpus petition. But if you look at the Supreme Court decisions limiting habeas corpus, if you look at the legislative history of the Anti-Terrorism and Effective Death Act, it was explicitly about states' rights in limiting federal court overview of what states courts do in criminal cases. So these are some of the primary areas where federalism is important historically, what's important today, is a limit on congressional power, is a way of empowering and limiting state governments, and also is a limit on the federal judicial power. Thank you.
Thank you so much, Dean. Professor Ross, you're up. Tell us about what's going on in the civil rights lens as we focus in on a particular issue.
Great. Thank you so much, Jennifer. And thank you, Erwin, for your comments and the always wonderful and comprehensive overview of Supreme Court doctrine and constitutional law. I'm going to focus in, as Jennifer said, on voting rights and civil rights, but a particular focus on voting rights. And I think that what I have to say about the evolution of federalism and where we are with respect to voting rights will be just as applicable to other civil rights domains as well. So as we often do, we kind of think about these issues starting with the text of the Constitution. And the text of the Constitution set forth in Article 1, Section 2, Article 1, Section 4, and Article 4, the Republican Form of Government Clause, seem to have left a lot of power over voting to the states. Article 1, Section 2 gave the states broad authority with respect to setting voter qualifications, not only for their own elections and their state legislatures, but also for elections at the federal level. At the time of the original bargain, only the House of Representatives was elected by the people, and the states had the power, state legislatures had the power to set voter qualifications. Article 1, Section 4 gives the states the power to establish the time, place, and manner of elections. And that one is subject to congressional supervision. Congress can override the time, place, and manner of elections as set forth for federal elections, but the states had primary authority over that. And when it came to state elections, of course, the states had complete authority with respect to time, place, and manner of elections. And then the Article 4 Republican Form of Government Clause gave Congress, the United States, the authority or to guarantee a federal Republican form of government. It wasn't quite clear what that meant, who the United States was, what it meant to guarantee a Republican form of government. But what was clear was that the states, in a sense, and what they had set up with respect to the Republican form of government that existed at the time of the framing was understood to be Republican enough, such that the United States would not interfere in those Republican structures. And so it was kind of a forward-looking approach in which if the government went in an anti-Republican direction, then perhaps the United States might intervene. That bargain has been adjusted over time, of course, with the amendments to the Constitution, the amendments being the 15th, 19th, 24th, and 26th Amendment. Those amendments established federal constitutional prohibitions on voter restrictions on the basis of race, sex, and age. And the 24th Amendment prohibited poll taxes in federal elections. And those amendments not only established constitutional prohibitions on voter discrimination, they also empowered Congress to enforce the amendments through appropriate legislation. And then you have the 14th Amendment. That amendment originally was not intended to be focused on political rights, but through judicial decision-making and social movement advocacy, the amendment, and particularly the Equal Protection Clause, has come to be understood as one designed to protect political rights. In addition to providing voter rights protection, each of these constitutional amendments also empower Congress to enforce through appropriate legislation. Congress has played a role in its enforcement through legislation passed immediately after the Reconstruction Amendment's passage in the 1870s, and then went through a period of inaction until returning to the fold in the 1950s to provide protection for voting rights. Now, from these constitutional innovations, two critical questions have emerged as central to the relationship between federalism and voting rights. First, how broadly or narrowly are the rights contained in the voting rights amendments construed? And second, how broad or narrow is congressional power to enforce the voting rights amendments through appropriate legislation? Answers to those questions have direct implications on federalism. To the extent that the court broadly construes the voting rights amendments and congressional enforcement powers, the narrower the scope for the states to exercise power over voter qualifications in the time, place, and manner of elections. And vice versa. To the extent the court narrowly construes the voting rights amendments and congressional enforcement powers, the broader the scope of states to exercise power over voter qualifications in the time, place, and manner of elections. But the matter is not merely about the scope of power. It is also about the availability of checks on abuses of power. The broader the construction of voting rights amendments and congressional enforcement powers, the stronger the checks on state power, and vice versa. Since around 2000, we have seen the court generally embrace a narrow construction of the voting rights amendments and congressional enforcement powers, thereby broadening the scope for the states to exercise power of voter qualifications, and the time, place, and manner of elections. In doing so, the courts have removed important checks on the states' exercises of power as they relate to voting rights. And what that has done is open the door to partisan capture of state legislatures, distortions of the democratic process, and unchecked efforts to suppress the vote. In this presentation, I will focus on 3 Supreme Court cases decided since 2000 that enhance the power of states over elections and diminish the effectiveness of federal constitutional and congressional checks on that power. Focusing first on the 2 cases diminishing federal constitutional checks on state authority over elections, those constitutional checks arose from the 14th Amendment's Equal Protection Clause's protection of the fundamental right to vote. A right understood not only in terms of casting ballots, but also in terms of opportunities for equal representation and participation. The first case is Crawford v. Marion County Board of Elections. That case was decided in 2006, and it was about the constitutionality of voter ID laws. The question arising in that case is whether states can impose voter ID laws, even impose voter ID laws, or whether the fundamental right to vote limited the state's authority to impose such laws. Now, the background of the decision, the decision were a series of cases decided in the Supreme Court from the 1960s through the 2000s, beginning with Harper v. Virginia State Board of Election. In that case, the court established the fundamental or preserved the fundamental right to vote that was established in the one person, one vote line of cases. The fundamental right to vote was understood to provide broad protection against any infringement on the vote, such that a state poll tax that required individuals to pay a fee in order to vote was said to violate that fundamental right to vote. Now, at the time that Harper was issued, it was thought that the fundamental right to vote protected against infringements on both severe and non-severe infringements on the right to vote. The idea was that any infringement on the right to vote perhaps would be subject to strict scrutiny and likely to be invalidated and presumed unconstitutional. But over the course of the next 3 decades, the court started to take a step back from that view. In a case called Burdick v. Takushi and a case that followed called Anderson v. Celebrezzi, the court differentiated between severe and non-severe burdens on the right to vote, and ultimately held that only severe burdens on the right to vote would be subject to strict scrutiny, whereas non-severe burdens would not. Now, in that consideration, the magnitude of state interest would come into play and would be balanced out against the severity of the infringement on the right to vote. When we get to Crawford v. Marion County Board of Election, we see the court wrestle with this particular test in the context of voter ID laws. And what was notable about that particular case was how the court applied a rather light burden on the state to demonstrate the magnitude of the state's interest in adopting voter ID laws. Although the state lacked really much evidence to support their claim that voter ID laws were necessary to address impersonation fraud or other threats to the integrity of the political process, the court was willing to embrace the asserted statement of interest even without proof. On the other side, the court put a heavy burden on the individuals to prove the severity of the burden on their right to vote. Now, in the background was a debate that has still not yet been resolved between Justice Scalia in concurrence and Justices Souter and Breyer in dissent. Justice Scalia argued that the severity assessment should be based on the overall burden upon the right to vote, not on a subjective assessment of the burden on particular individuals or groups. Such a severity assessment will in most cases make it less likely that a court will find a particular voter restriction to be severe, as it appears to require that more people be burdened by the restriction. Justice Souter and Breyer in dissent argue that the severity assessment should be based on the burden on the right to vote for particular individuals and groups. If the court had embraced that particular severity of assessment, it made it more likely that those who are burdened by the right to vote, burdened by a voter restriction, would have their rights to vote protected under the Constitution's fundamental right to vote. Now, that has been resolved, but based on the current composition of the court, it's likely that the court will embrace over time the Justice Scalia approach, which focuses on the overall burden of a particular restriction on the right to vote, which would require not only that the restriction be quite severe, but also that the restriction be broadly severe on a broad population. Now, if you combine the light burden on the state to prove the magnitude of its interest in adopting and maintaining voter qualifications and the more difficult to prove severity assessment, state authority to adopt and maintain facially neutral voter qualifications that nonetheless suppress the vote will be subject to limited federal constitutional checks. The only way such facially neutral voter qualifications will be found to run afoul of the Constitution is if they are motivated by discriminatory purpose, something that's very difficult to prove, of course. Now, the second case is Rucho v. Common Cause, which Erwin already touched upon, so I won't go into the background too much of this particular case, but instead elaborate on some of the points that Erwin made in his comments. Now, this court has been struggling with the question of the relevance of the Constitution and whether the court should apply the Constitution to check state legislative efforts to engage in partisan gerrymandering. Once the Supreme Court imposed on the states the one person, one vote requirement, that opened the door to state legislatures playing a more active role in drawing district lines. Self-interest enters into the line drawing process, so state legislatures drew districts to either give themselves an electoral advantage, their party an electoral advantage, or both in district elections. The question that then arose was what, if any, were the constitutional limits on state legislators districting for those self-interested reasons, particularly when it resulted in an unequal participation or representation for one of the party's members. In the 1986 case of Davis v. Vandermeer, the court came up with a standard to police partisan gerrymandering, but it was so easy for the state to satisfy that it imposed a limited check on the practice. In the 2003 case of V. Jubileer, members of the court came up with 3 different standards, but there was no majority agreement on any of them. And while Justice Scalia saw this as proof of the non-justiciability of the issue of partisan gerrymandering, Justice Anthony Kennedy, who served as the pivotal 5th vote on the question, did not want to give up on the issue yet. What resulted was over a decade of work by legal scholars, political scientists, and others trying to develop a standard and metric for partisan gerrymandering that would satisfy Justice Kennedy. By the time the issue returned to the court in Rucho, Kennedy had retired, and Justice Roberts wrote for the majority of the court that deemed partisan gerrymandering a non-justiciable political question. Justice Roberts declared that there was no judicial standard that could reliably differentiate unconstitutional from constitutional political gerrymandering. In declaring partisan gerrymandering non-justiciable, the court removed the federal constitutional check on the practice, leaving only the state courts applying state constitutions and independent redistricting commissions as the only institutional check on state legislatures. This term, the court may decide the question of whether state courts can continue to serve as checks on district line drawing by state legislators. Although the issue might have been rendered moot as a result of the North Carolina Supreme Court's decision to overturn its prior decision declaring the North Carolina state legislatures gerrymandering inconsistent with the state constitution, there is still the possibility that the Supreme Court, U.S. Supreme Court, decides the issue anyways in favor of removing another check on state authority to draw districts. And even if it doesn't decide to rule on that case or finds that the independent state legislature does not limit state judicial authority to review state legislative line drawing, what happened in North Carolina is a revealing and worrying development. What it exposes how the politicization of the courts can make them partners in, rather than checks on, partisan manipulation of politics through practices such as partisan gerrymandering. In other words, state judicial involvement in the review of partisan line drawing may not be much relief at all if state courts are aligned politically with the state legislatures. The first 2 cases I discussed, Crawford v. Marion County Board of Election and Rucho, reduced or eliminated the effectiveness of the federal constitution as a check on state authority over voter qualifications and the time, place, and manner of elections. A third case eliminated an important congressional check on state authority over elections. That congressional check came in the form of Section 5 of the VRA, a measure designed to protect the voting rights of racial minorities against state efforts to suppress or dilute their votes. And the case eliminating that important check was Shelby County v. Holder, and the Shelby County Beholder, which described the Section 5 of the Voting Rights Act as a radical departure from federalism norms and questioned its continued need. Now, Section 5 of the Voting Rights Act was part of the original 1965 Voting Rights Act, and it was a provision that worked in partnership with Section 4 to subject states with history of discrimination to a pre-clearance requirement. In other words, they had to obtain pre-approval for any changes that they adopted. And in that pre-approval process, the covered states would have to prove that their change would not have the purpose of discriminating or the effect of discriminating on the basis of race. Now, this provision proved highly effective. It prevented the manipulation of the voting process that states had engaged in for decades to prevent African Americans from participating in the political process. Even after the Congress had passed laws to address voting rights in the 1950s, states were able to continue this manipulation because of the difficulty of enforcing these laws in courts. So Section 5 provided a means to bypass the courts and requiring that bypass the burden that's often placed on litigants to prove that the law discriminates against them on the basis of race, and place that burden instead on the state to prove that it does not. They would have to prove that it does not before the United States Attorney General or the District Court for the District of Columbia. As a result of this act, many those covered states were prevented from enacting discriminatory laws, and we saw a tremendous gains in turnout and registration and turnout, and even tremendous gains in office holding itself as a result of the legislation's response to vote dilution practices. Now, in Shelby County, the court held, after seeing all those successes, that the current burdens on state authority from the act were no longer justified by the current needs. And when they're talking about the current burdens, they're really thinking about it from the perspective of federalism and the concern that this is requiring or placing too much of an onus on states to pre-clear their election changes with the federal government. And the court, in assessing that the needs were no longer relevant, pointed to increases in minority voter registration and turnout, highlighting in particular the 2008 and 2012 elections, which featured the first major party presidential candidate of color. And in doing so, the court treated the VRA as a victim of its own success. What it overlooked, however, was that those successes were the product of the deterrent function that Section 5 of the VRA played. Justice Ruth Bader Ginsburg suggested in her dissent that when the court removed the umbrella of Section 5 of the VRA, those gains from the VRA would be in jeopardy. And that is exactly what has resulted. Almost immediately after removal of the congressional checks of the critical Section 5 of the VRA, previously covered states like North Carolina and Texas passed voter ID laws. And since then, there has been a constant flow of voter suppression laws and practices from previously covered states. So where are we? We are at a point at which state authority over voter qualifications and the time, places, and manner of elections are subject to fewer checks than they were before. One might argue that such an arrangement is consistent with what the framers designed. But such an argument would ignore the relevant context of the original constitutional agreement. That context was one in which factions were nascent and local, rather than fully developed and national. And that matters because natural operation of federalism assumed the ambition of local power, that the ambition of local power would counteract the ambition of national power and vice versa. For the framers, that notion of checks and balances limited, but did not eliminate the need for judicial or other external constitutional checks on power. But in a context in which factions in the form of parties are fully developed and national, that ongoing factual basis for the framers' assumption is highly questionable. It appears now that the protection of national party interests has emerged as an increasingly powerful consideration for lawmakers, overriding contestations between national and local power. That overriding focus on advancing national party interests makes such judicial or other external constitutional checks on power much more pressing, if not paramount. In the absence of such checks, we are seeing partisan manipulation of representative structures as resulted in partisan capture of institutions. Such partisan capture of institutions is giving rise to institutional actions that are increasingly anti-democratic. Examples include the expulsion and silencing of state-elected lawmakers by state legislatures controlled by Republican supermajorities in Tennessee and Montana, state legislative overrides of independent redistricting commissions in states like Ohio, and changes to election laws in states like Florida to cater to the presidential ambitions of the state's governor. We are seeing widespread efforts to suppress votes in the form of laws limiting access to voting and making it more difficult to vote, and official acts of voter intimidation through such things as voter fraud integrity units in Florida. And all of these practices have thus far gone unchecked, in part due to the Supreme Court's removal of federal constitutional and congressional checks in the three cases I've described. That's my account of the relationship between federalism and voting rights in this current moment. All of these things are subject to change, of course, but I agree with Erwin when he says that right now the Supreme Court seems more inclined towards a further removal of constitutional and congressional checks rather than their reestablishment. And that is quite worrisome for the future of the American Republic and the democratic Republican form of government that many of us cherish so dearly. Thanks so much, and I look forward to Julie's comments and the conversation that follows.
Professor Ross, that was a little depressing, I have to say. I mean, I very much appreciate your presentation, but I was hoping for maybe a little more upbeat assessment of where we are in terms of our democracy. Oh my goodness. Well, maybe in the Q&A, someone will get you to give us some light at the end of the tunnel, although we shall see. Great, Professor Zook. So I don't know if any area of law is as much of a mess as reproductive rights right now. I mean, I suppose there's competition, but there's certainly lots to talk about in terms of what's been happening since the Dobbs decision last year. We very much look forward to hearing from you about this issue.
Well, thank you very much, Jennifer. It's such a pleasure to be on a panel with Erwin and Bertrand. And I'm glad that you punted the uplifting bits to the Q&A rather than to my presentation. But I want to start with Dobbs being a decision about federalism, and not just federalism, but federalism as a certain vision of representative democracy. And then I just want to assess what we're seeing on the ground after Dobbs with regard to abortion regulation in the states, as well as federal law affecting those regulations. So if you think of the criticism of Roe that the Dobbs court put forth, it was, of course, a criticism that came from a resistance to judicial power because it was anti-democratic, and anti-democratic because it limited what the states could do with regard to abortion, on the theory that really it's the states where people through their elected representatives give reality to their moral views on important and sometimes divisive issues, such as abortion. So the Dobbs court says very early on in the opinion, Roe imposed the same highly restrictive regime on the entire nation, and it effectively struck down the abortion laws of every single state. So there's this notion that having one national standard on abortion is undesirable and unworkable from the standpoint of democracy. The court then pointed to 26 states have expressly asked this court to overrule Roe and Casey and allow the states to regulate or prohibit pre-viability abortions. And then very importantly, and this has been quoted a lot since then, it is time to heed the Constitution and return the issue of abortion to the people's elected representatives. And so, of course, as Erwin has given many examples of, the whole idea of states' rights has often been used to resist inclusive understandings of democracy. And it's important to note that a very significant limit to states' rights emerges from the Civil War and the amendments to the Constitution, the 13th, 14th, and 15th Amendments that emerge from the Civil War, which limit the power of the states over certain domains and empowers Congress to enforce the guarantees in those amendments. And but nonetheless, Dobbs really puts forth a vision of democracy, and not just democracy, but national pluralism, by which abortion allowing states and abortion permitting states that constitute the United States as a federated nation can coexist. And there could be laboratories of democracy and experimentation on this issue with these states coexisting. And of course, what we've seen in terms of legislation that has been passed since Dobbs, well, I wouldn't say it's been passed since Dobbs, because we had many states in anticipation and desire for Roe being overruled had already passed abortion restrictions that were flagrantly in violation of Roe v. Wade, and many federal courts had cited Roe to enjoin those abortion bans or near total abortion bans, like 6-week bans, or even like 12 to 15-week bans. But in Georgia, Alabama, Arkansas, Missouri, Kentucky, Mississippi, North Dakota, Ohio, these are some examples of states where there was litigation where the abortion bans were were enjoined by federal courts. But of course, many of the state legislatures, including Mississippi, the Mississippi abortion ban that was upheld in Dobbs was a 15-week ban, but it was very high stakes because Mississippi had also passed a 6-week ban. And that was and many other states had passed trigger bans, which after Dobbs was decided throughout the summer, July and August, there were little proclamations by state attorneys general saying that the trigger bans, which were as restrictive as either 6 weeks or even from the moment of conception, a ban on abortion with very few exceptions, to save the life and health of the mother. So we have in many, many states these either 6-week or from the moment of conception bans going into effect with very few exceptions. And then on the other hand, in the abortion access states, there's a lot of activity not only on the statutory level, but state constitutional amendments around reproductive rights. And so we get California, Vermont, and Michigan passing constitutional amendments that protect reproductive freedom, and they're framed to explicitly protect the right to abortion as well, such that the right can only be restricted when there's a compelling interest. So it's just trying to bring the law as it existed under Roe, at least under Roe and Casey as the state law. With regard to constitutional guarantee of reproductive freedom. We see some activity that's still in progress in New York, but it's in New York, there had been for many years negotiations about adding a general equal rights amendment that would protect sex equality, including gender identity, pregnancy, sexual orientation, and many other categories to the New York State Constitution. About a week after Dobbs was decided, the state legislature met in a special session to pass that amendment with language also protecting against discrimination based on the exercise of reproductive autonomy or healthcare, clearly, which is about abortion. And the preamble to that amendment explicitly says this is a reaction against Dobbs. That amendment passed in July 2022, and then again earlier this year, so it will be up for referendum in December or November 2024. So you see that kind of activity. And then Nevada also had already in progress legislatively enacted equal rights amendment that referenced pregnancy and gender identity and additional categories of sex equality. And that passes in a referendum in November, where there's discussion of Dobbs and abortion rights as at least one of the concerns animating a renewed interest in sex equality. And so these are just some examples of states using state law, including state constitutional law, to protect abortion access in the abortion allowing states. And on the other hand, a large number of states passing new, much more restrictive abortion bans than we had imagined possible under the Roe regime. And this raises this question as to whether abortion allowing states and abortion permitting states can actually coexist. I've certainly heard some commentators, including Michelle Goodwin, suggest analogies to past moments where we have slave states and free states, or we have segregationist states and integrationist states. But I think this analogy to the pre-Civil War moment is a useful one for us to think about. And in part because it's not totally, I mean, you could even think of the problem of the abortion ban as being very closely connected to the problem of slavery. Many commentators, including Michelle Goodwin and Dorothy Roberts and Andrew Koppelman, and myself, have suggested in some writing that abortion bans, because they force women to bear children, even children conceived through sexual assault can be seen as a form of slavery or involuntary servitude, which were arguably included in the 13th Amendment ban on slavery and involuntary servitude. So, so I think that analogy is there. But even if you don't accept that forced motherhood is slavery, this notion, though, that you can have some states that ban abortion and effectively force motherhood, and others that don't, and that we coexist, I think looking abroad to models of federalism in Europe can help us see more clearly the problem of having abortion permitting and abortion prohibiting states that make up a shared or federated entity. Specifically, if you look at the evolution of abortion in Ireland, which was highly restrictive, but Ireland participating in the larger entity. I mean, there's a lot of academic discussion as to whether federalism is the right frame for thinking about the relationship of the European Union and the European Convention on Human Rights system to the member states of the European Union. So it's not exactly the same kind of federalism necessarily that we have here in the United States, but there is no question that the free movement of goods and services in the European community was a foundational principle that began to unravel the Irish ban on abortion in the late 1980s, because in Ireland, Irish women traveled freely to Britain and to the Netherlands and other member states of the European Union to get abortions, even though it was highly restricted and criminalized in Ireland. And so it raises the question, of course, as to whether in the 21st century nation that America has become, governed by our federal constitution and by federal law, it's actually possible for abortion ban states to coexist alongside abortion access states. Dobbs' answer is, of course, yes, because there cannot be, according to Dobbs, a national solution due to deep disagreement about abortion, which is why each state has to be left to decide for itself. And this takes me back to just thinking about historically what happened when we tried to have slave states and non-slave states. It takes me back to the Lincoln-Douglas debates after Dred Scott and before the Civil War, where Lincoln and Douglas grappled with the assertion that we could actually have popular sovereignty in the states on the question of slavery. That is, of course, Stephen Douglas argued that every single state should be left to decide for itself whether to be slave or free, in much the same way that the Supreme Court has argued that each state should be able to decide whether or not it will have abortions, whether or not it will force motherhood. And one of Lincoln's rejoinders was to show that allowing states to decide for themselves actually prevented abolitionist states from realizing their democratic moral vision, and eventually arrived at the conclusion that the nation would have to be either pro-slavery or anti-slavery. And I think we're seeing a similar dynamic in the United States over abortion. Because abortion ban states cannot really exercise complete sovereignty to stop their inhabitants from obtaining abortions in the context of neighboring abortion access states and federal law, including FDA approval of the abortion pill. Justice Kavanaugh's concurrence in Dobbs recognized this to some degree by acknowledging that there was a right to travel. And I should mention that in the Irish context, while a lot of this was brewing, there was a constitutional referendum that explicitly protected the right to travel and the right to information coming from other countries with regard to abortion. And so that's one thing, that people will be able to travel, notwithstanding certainly class effects on using the right to travel as a proxy for a right to abortion. In any case, even without people crossing territorial boundaries between the states, there is, of course, telemedicine and mail, and the whole framework of federal regulation, including approval of drugs like mifepristone, So a state ban on abortion is not quite that effective, because even though if you have a ban that says that abortion is illegal from the moment of conception, if you have mifepristone on the market with FDA approval, and other states, and this is another form of pro-abortion access activity that we're seeing in some states, which is the development of abortion shield laws that will shield providers in one state that may be providing abortion healthcare to people in another state through telemedicine and through the mail of abortion pills. So on this question, of course, we got the conflicting rulings on mifepristone from the Ninth and Fifth Circuits, or rather the district court in Seattle, in Washington State and in Texas with the Fifth Circuit's order. So it's not directly a federalism issue as much as it is a circuit split with regard to different conclusions on federal law and the validity of FDA approval at various moments. But certainly you end up with these different rulings because the states that are abortion permitting have been litigating to ensure the protection of FDA approval of mifepristone in the context of telemedicine or not having the in-person visit, whereas other states that are abortion banning would like to make it illegal to take mifepristone in those states, including if that mifepristone is dispensed through telemedicine and mail by doctors who are protected by abortion shield laws. So there's a total limit to the extent to which an abortion banning state could be very effective in actually banning abortion in this framework. And I think another historical analog that we could be thinking about is the experiment with the prohibition of the manufacture and sale of alcohol in the 18th Amendment, which is repealed by the 21st Amendment. Prohibition comes about because there were actually many states and localities that were trying to ban alcohol, but due to the Dormant Commerce Clause, they really could not stop alcohol from being shipped into the state from other states where it was actually legal. And it wasn't really practically working for each state to have its own rule. They really couldn't keep alcohol out. And that's what led to the 18th Amendment being adopted and ratified. And it's interesting that by the time that the 18th Amendment is repealed by the 21st Amendment does not simply repeal the Prohibition Amendment, but has a provision that leaves it to the states, preserves some state autonomy, makes it illegal to ship alcohol to states in violation of state law. But there's a need for, first of all, a constitutional amendment because states are unable through the ordinary exercise of sovereignty to actually have a rule banning alcohol. But then in order to protect them, you need another constitutional amendment that not only repeals that, but protects states that want to shield themselves from the influence of other states with regard to alcohol coming in. And so I think these examples then bring us to thinking about how really what's happening is a fight about federal law. On the one hand, Dobbs says that you can't have one rigid national standard, but those who oppose abortion, the anti-abortion movement is taking steps to stop national access to abortion in order to address this problem. And there are some commentators, of course, that have been bringing out the real goal of the anti-abortion movement, or at least some parts of the anti-abortion movement, which would be a national, possibly constitutional ban on abortion or protection of unborn life. in any case, to the extent that you see activity that's no longer really just about the states, but about having a national standard on abortion, the ruling from the district court in Amarillo, this is Judge Kaczmarek, invalidating FDA approval of mifepristone, and then the Fifth Circuit invalidating the FDA approval of mifepristone without in-person visits. The Fifth Circuit version, which is not as extreme as Kaczmarek's, would effectively keep the abortion pill, or mifepristone, not misoprostol, but mifepristone, out of the anti-abortion states, because if you have a rule that still requires in-person visits, the primary way in which it enters the anti-abortion states would be telemedicine plus mail, which would be illegal. And so the Fifth Circuit and Kaczmarek, to differing degrees, tries to help the anti-abortion states keep abortion and abortion pills outside of those states. But very interestingly, the method of doing this is looking for a strong national standard in the form of what we thought was essentially defunct, the federal Comstock Act. And I see that just yesterday we had another ruling in West Virginia by one of the generic manufacturers of mifepristone that disagree with the interpretation of the Comstock Act that you see in both Kaczmarek's ruling and the Fifth Circuit ruling. The Comstock Act textually says that you can't mail things intended to cause an abortion. And we have federal court and OLC opinions limiting the scope of the Comstock Act so that it's very limited to prohibiting only mailing the abortifacients that are intended, or where the sender knows that it's going to be causing an abortion. But the Comstock Act, as interpreted, which is federal law, by Kaczmarek's ruling, as well as the Fifth Circuit, would put us in the situation that I think Abraham Lincoln was describing in the context of the Lincoln-Douglas debates with regard to slavery, which is the situation where abortion access states, abortion permitting states, would then themselves be hobbled in their efforts to protect abortion access in their own states for their own residents. Because if mifepristone is taken off the market, or if the Comstock Act is read to simply plainly textually prohibit the mailing of anything that's intended to cause an abortion, it means that you can't mail any drug or device used in abortion, period. And if you can't mail those things, it seems like unless every state is manufacturing everything that's needed for abortions, this is going to severely restrict the ability of abortion permitting states to be abortion permitting states with that strong understanding of this very old law. And so, of course, now we're also getting these conflicting. So we're getting conflicting interpretations of federal law, both the FDA approvals as well as federal law in the form of the Comstock Act that are then serving different purposes with regard to states that are trying to keep abortion out of their borders and states that are trying to provide greater access. Even, this is notwithstanding, like the states that are trying to provide greater access are not just trying to serve people in other states, trying to get services from their state, but also their ability to provide abortion access to the residents and citizens of their own states. So I think it does sort of leave us with some serious questions about the viability of federalism as the theory of democratic representation. I know certainly others like Melissa Murray and Kate Shaw and Reva Siegel, many are also writing about the question of democracy that's raised by Dobbs. And we're certainly seeing and I think we can talk about this some more. We're certainly seeing dynamics in some of the state legislatures that have banned abortion that create some pause about whether we can even call that democracy. I'm specifically referencing there's been a movement in Ohio to get a reproductive freedom amendment on the ballot for a proposal to amend the Ohio Constitution to protect reproductive freedom. But there's activity in the state legislature seeking to raise the bar so that you would need a 60% rather than majority vote to approve such an amendment. So I think that's also another set of questions about the model of democratic representation that I think is separate that we can talk about. But certainly some of the practical dynamics that we're seeing here is that it seems like with the problem is that there doesn't seem to be a way for states to exercise complete sovereignty with regard to being abortion banning or abortion permitting in light of the practicalities of how most abortions, or at least 50% of abortions, are now dispensed in this country through medication. And so I think it does point to, like it or not, the need for a national compromise, whether it's on the FDA, whether it's on the Comstock Act, or ultimately on just having a federal statute with regard to the status of abortion. The Women's Health Protection Act would protect all of the rights, I think, that were in Roe, a broad negative right to abortion, but would keep the Hyde Amendment in place. That was filibustered in the Senate last session, and now with the GOP in control of the House, it has less of a chance of passing this Congress than it did the last one. On the other hand, there is a proposal to ban abortion at 15 weeks. Lindsey Graham has sponsored that, with abortion permitted after 15 weeks, only for very narrow exceptions to save the life of the mother. And I think this is where, if the only way that these states that have very different views on abortion can coexist, not through state sovereignty, but through a national compromise, I think we need to be asking much larger questions about the way that our respect for states and their significance to people's exercise of democratic power. I think we need to be asking those larger questions about that. If you think about, even at the federal level, why it's been so hard to come to a national compromise. We're polarized in part because the Senate, which is very powerful, represents the states and represents them equally. And as Bertrell mentioned, it's state legislatures that control congressional districting maps. And then if we ever were to get into the conversation about possibly amending the US Constitution to come to national compromises on these issues, it's state legislatures, 3/4 of them, that would have to ratify any amendment proposals. So I think I'd just like to end on the note of raising this practical problem with the vision of democracy that we often defend. That really locates democracy in the states, and perhaps the path forward is to see how unworkable it is on these divisive moral issues and work towards repairing our national lawmaking structures in ways that allow people to make policies that they can live with in a nation that's pluralistic and with divided views.
Wow. Okay. Well, we got a lot of questions coming into the Q&A while you were speaking, Professor Suk. This is an issue that raises a lot of strong feelings, I think, among people, of course. But I want to go back. Well, actually, what I would like to start with is to bring Dean Chemerinsky and Professor Ross, if you wish, into your last set of comments, this notion of needing to have a national compromise and raising questions about federalism is supportive of democracy in light of what we're seeing with the abortion debate. It's a huge question. And I mean, I hear you, look at what's happening on the ground, and how can we not seek something like that, putting aside whether it's feasible politically. But what Dean Chemerinsky and Professor Ross, do you think about this challenge of saying that we're not really supporting democracy through federalism when you look at what's gone down in connection with Dobbs and what's happening in its aftermath?
Yeah, I'll let you go first. Dean.
First, I don't think that democracy inherently supports, that federalism inherently supports democracy. Federalism can support democracy, but federalism can also undermine democracy. Here I'll focus on what Bertrand was saying. To the extent that states are engaging in practices that systematically disenfranchise minority voters, to the extent that states are engaging in partisan gerrymandering, I think then states' rights is very much at odds with democracy. I think this has been true throughout American history. In 1964, only about 43% of eligible Black voters were registered to vote in Southern states. In Mississippi in 1964, only 28% of eligible Black voters were registered in Southern states. Federalism and states' rights was very much the antithesis of democracy then. Allowing unchecked partisan gerrymandering is the antithesis of democracy. With regard to abortion rights, if one believes, and I do, that the right to abortion is a fundamental right under the Constitution, then states should not have the ability to take that right away. I don't know how we're going to get a national compromise on any of these issues. There's never been a national compromise that worked with regard to civil rights. There's never going to be a national compromise that works with regard to abortion. There's no middle ground between those who believe that there should be abortion rights and those who want to take away abortion rights. I think the question is, should this be an area for federal law protecting voting rights, protecting the right to abortion, or should we leave it to each state? And I very much come down on the former side, that these are matters that should be protected by the national government and shouldn't be a matter of states' rights.
And I think that in terms of thinking about the relationship with federalism and voting rights, or federalism and democracy, I very much agree with what Erwin has said. And I guess I'll just add to it that we could think of federalism as reinforcing voting rights, but it requires, or democracy, excuse me, I keep going back to voting rights, if we think of the Constitution as establishing a democratic floor. And what I mean by that, establishing a floor below which anti-democratic actions would be subject to review and invalidation. And we had, constitutional provisions playing the role of the floor for a brief period of time, right? We had Congress and the courts reinforcing each other from, the mid 1960s through, perhaps the mid 1970s and maybe early 1980s with respect to how the Constitution is being interpreted with respect to the 14th Amendment and protecting minority voting rights, protecting against minority vote dilution, providing for equal representation, equal participation, and just establishing a floor for the states. And then there was the possibility that states could innovate in ways that were productive towards a better democracy. There are opportunities to develop new mechanisms of voting, new means of new types of representative structures that would bring, make the particular states more democratic rather than less. But when you eliminate those, that floor, and you provide, in a sense, for an opportunity to move in as anti-democratic a way as you prefer, and you combine that with partisanship and the degree in which our parties are at each other's throats and the disagreements that exist within our polity, it makes it hard to imagine that there will be any give towards or any desire to maintain any sort of democratic structure. There's always the threat that any party will seek to protect its own interests and advance its own goals at whatever cost, and even if it means the cost of democracy itself. And then on the lighter point, I do agree also. It's hard for me to imagine what that moral compromise would be. I taught constitutional law, and I ask my students to think about what's the ultimate goal behind the pro-life movement. Is it to give the states the power to decide these questions, or is it to protect life? And I think the pro-life movement is about protecting life. And I don't think that there is a sense that that is to be compromised. And so to the extent that we have a high plurality of the American people who are supportive of that particular movement, I just can't imagine what that would be, what that compromise would look like, other than a ban on abortion.
Julie, do you want to respond?
Yeah, no, so I spend a lot of time looking at other countries, and there's no country in the world. I mean, I watched the Senate Judiciary Committee hearing on the assault on reproductive rights after Dobbs, and it seems like the pro-life position is that we need to protect life. But what came out in the hearing is that the pro-life witnesses admitted that in a situation where a woman's life was in danger, she should have been offered a termination, and not in danger like medical emergency danger. Even just it's up to the doctor to assess that risk. And that is not, and we're already, if you have a law that just says that you're banning abortions at 15 weeks, and then after that, pre-viability only to protect the mother's life or health, that's already a violation of Roe. We have compromised from Roe if we've gone there. But in many other countries, that's the law. The countries that we consider the liberal abortion countries, they have many more restrictions in place after 15 weeks than would have been compatible with Roe, but they also have funded abortions. They don't have the Hyde Amendment. And what's really interesting to me is that the Women's Health Protection Act in the United States always includes the Hyde Amendment. They don't disturb that. I mean, the pro-choice people never like the Hyde Amendment, but that's already a compromise. If you have a broad negative right, but zero funding for poor people who need it, not only for life reasons or health reasons, we're already compromised. A different compromise would be within 12 weeks, it's totally funded. After that, it's more restricted. That's different. That's the compromise they have in Ireland. And now there's a study really looking at how to make that first 12 weeks access much more meaningful than it has been on the ground in the last few years since that went into effect. And that's what I'm talking about when I say that there needs to be a compromise, because I think we don't realize the extent to which the thing that we thought was abortion protective, the right to abortion, was itself highly compromised in ways that severely restricted access to abortion, especially for poor women and women of color. So, but I think that it is true that the compromise conversation doesn't happen at the national level, in part because of the way that we have privileged the states, even in the context of national lawmaking, in the way that we've structured Congress, particularly, and certainly also in the way that we elect the president. So I think, I mean, when I suggest that we need to move towards a national compromise, I don't think we get very far if we left the existing structures, which are also federalism-inspired structures, in place. And so that's what I'm trying to say about that.
So another kind of broad-based question, I think, at least starting for you, Dean, comes from one member of our audience, Faith, and she's asking about, as you discussed, the kind of ebb and flow over history of the court shifting the way that it looks at these things, stronger congressional power, weaker congressional power, et cetera. And she wants to know whether, in your view, that impacts the public's view of the legitimacy of the court, and whether it should. A lot of people are talking about that now, as the court is so far to the right and its public approval ratings. I don't know if it's an all-time low, but they're pretty low. So the question is that how we should look at the legitimacy of the institution? What do you think of that issue as someone who studies the court so closely?
The Supreme Court has the lowest approval ratings in history. A Gallup poll last June had only 25% of the American public expressing confidence in the Supreme Court. A Marquette University poll in July had 61% expressing disapproval of the court. I'm not sure what we mean when we talk about the legitimacy of the court. I often think it gets invoked in a very general way without having content, but certainly one measure, whatever we're talking about, is the disapproval of the court. Why is the court's legitimacy so low? I think some of it is that there's low approval of all of the institutions of government right now, and I think the court is hurt by that. I think some of it is a result of the current court's very conservative decisions that are against the weight of public opinion. The majority of Americans thought Roe versus Wade shouldn't be overruled. The majority of Americans favor much more in the way of gun control. And so in that sense, I think the Supreme Court is suffering. I think now the ethics controversy concerning the Supreme Court hurts its legitimacy. It's truly a self-inflicted wound that the court hasn't developed an ethics code and some enforcement mechanism like that exists for all other judges. In terms of the court changing its views, I don't know overall how much that affects its legitimacy. I think the court legitimacy was enhanced when in Brown versus Board of Education it overruled Plessy versus Ferguson. Not immediately, but over time, I think people regarded that as the quintessential of what a Supreme Court should be doing. I think the Supreme Court in 1937, overruling the Lochner of 40 years of jurisprudence, ultimately helped the court's legitimacy. I don't think the issues of federalism on the surface are the most salient with regard to the court's approval rating, but I think they're related to the court's approval rating. In the 1930s, the court's legitimacy suffered enormously, and there's a crisis of confidence in the court, the proposal of court packing, in part because of how the Supreme Court was using federalism to strike down New Deal legislation. When we look at abortion through the prism of federalism, we see how the Supreme Court's decision in Dobbs contributed to undermining its legitimacy. So I guess what I'm saying is talking about legitimacy is inherently complicated, and there's many things that contribute to the court's approval or disapproval in the public eye. I think this is part of that.
Sorry, I was muted. Professor Ross or Professor Sook, anything you'd like to add? Okay, sorry, my friend here is acting up a little bit. We have a question from another audience member, Max, who would like to hear a little bit more about preemption. And basically where you think, Dean, preemption is headed as a legal doctrine.
Sure. It's interesting. I would expect that conservative justices who care about states' rights would want a narrow view of preemption, because the narrower there is federal preemption of state law, the more that's left to state governments. And yet it didn't work that way. During the Rehnquist and the Roberts eras, it's often been the conservative justices who are taking a much broader view with regard to preemption. So I think of Lorillard Tobacco versus Riley, where the Supreme Court said 5-4 with the conservative justice in the majority, that a federal law that concerns regulating labels on cigarette packages preempted Massachusetts from regulating where cigarette ads could be located, like not near schools or playgrounds. Or I think of some cases from the last decade under the Roberts Court, such as Pleva versus Mensing, where the Supreme Court broadly preempted the ability of states to create liability for generic drugs. These again were 5-4 decisions with the conservative justices in the majority. To me, what it reflects is the conservative justices being pro-business, and therefore their pro-business orientation has led them to be willing to find preemption of state and local business regulation.
We have a question from Stephen. I think it's probably for you, Professor Ross. Stephen asks, what future role, if any, do you see for the requirement for a, quote, Republican form of government in addressing either state voting restrictions, gerrymandering to assure continuing minority rule of legislatures, or the independent state legislatures theory?
Yeah, it's an interesting question. As we know, the court has suggested, and I won't go as far to say as that they rendered the Republican form of government clause non-justiciable. I do think that they, in the efforts to broadly apply it in a couple cases, cited one in the 19th century, one in the early 20th century, the court was very reluctant to, to rely on the Republican form of government to basically choose which government governed in the case of Rhode Island, or to, in a sense, invalidate a whole lot of state laws in the case of Oregon. But I think that there is potential that is untapped and it could possibly be tapped with the current Supreme Court. You want a dose of optimism here. Well, I think that the optimism comes from the methodology that the court has used in the Dobbs case that could be leveraged for a favorable result when thinking about Republican form of government. If you look to the history and tradition of Republican form of government as it was applied and understood in the 19th century, there is a broad sense that Republican form of government was designed to protect a fundamental right to vote, a system of government in which minority voices were heard, and was very much in opposition to partisan manipulation of the political process. And these understandings of Republican form of government emerged in state constitutional conventions throughout the 19th century in the several states that had the convention, in which the focal point was really on defining what Republican government meant and defining what it did not mean as anti-Republican. So what were the things that were considered anti-Republican? Well, they included property qualifications for voting because it infringed, it treated voting as a privilege rather than a right. It include giving legislatures the authority to draw district lines because they were concerned about that very manipulation that we're seeing right now. They considered that to be anti-Republican. And so looking back to that history and tradition of Republican government could give an opening for the protection of those rights that are under threat right now, and could counteract the efforts to distort the political process that we're seeing in state legislatures throughout the country. I'm not sure in terms of how consistently the court will apply its methodology. I don't know if it will be used only for the results that it might favor as a value from a value judgment perspective, or whether it will be used broadly and consistently. And if so, there is at least opportunity with respect to our democratic process.
Professor Sook, I'm going to combine a couple of questions here for you. One of them is, what is the outlook for ratification of the ERA, and to what extent, if that ever happened, could that deal with the abortion issue and other women's rights issues? And the second question is, you mentioned a possibility of a national ban, a law that Congress would pass banning abortion nationwide. How would that play out? Like, if let's say Congress passes a law, what happens then? Who would come forward to challenge it, saying, like, in my state of New York, my constitution guarantees me the right under our constitution? And then how would those challenges play out if you kind of took them through their paces?
Great. So two great questions. So with the Equal Rights Amendment, its relationship to abortion is not obvious and complicated, but has become more connected to abortion because of the Dobbs case, and not just the outcome of the Dobbs case having to do with abortion, but as Bertrell mentioned, the methodology of the Dobbs case. So specifically, the Equal Rights Amendment gets proposed on the heels of the 19th Amendment, and it's not adopted until the early 70s. And I think the compromise in the early 70s was that there were Republicans and Democrats, including some pro-life Republicans, including Peggy Heckler in Congress, who supported the ERA but they didn't really talk about abortion. It was really about ensuring equal rights at a time when there were laws that actually excluded women from certain things still, even in the 60s and 70s. But the relationship to abortion wasn't talked about then, so it didn't really become part of its meaning. And throughout the time of ratification, until some of the opponents, including Phyllis Schlafly, talked about how the ERA would actually protect abortion. And that wasn't outlandish, because many legal feminists believe that it's not possible to live as an equal citizen in the United States without some degree of reproductive freedom. That may or may not match up to the degree or type of reproductive freedom specifically protected under Roe. So in terms of the prospects, as perhaps the audience knows, it came 3 states short of ratification in the late 70s. There was a deadline. Congress extended the deadline, but no additional states ratified. But after Trump was elected president, I think in part in reaction to the misogyny and the Me Too movement, you got 3 additional ratifications from 2017 to 2020. And then the House took action almost immediately to say we're removing the deadline for good. So retroactively recognizing those 3 ratifications. There's also this complication that 5 states rescinded. But the Senate didn't take action. But the Senate actually voted last week to remove the deadline and just recognize the ERA as ratified. But we're in a new congressional session, and it's unlikely that the House is going to do it in this legislative session. And the Senate vote, even though it's a majority in support, so that seems democratic, the majority supports it. But of course, we have the filibuster. So it was a cloture vote, and it didn't clear the cloture vote. So even though we have on record 51 senators in support of removing the deadline, it's not effective as a legislative action. So that's where we are. I think if a future Congress it's possible that a future Congress, there is some bipartisan support, but not enough bipartisan support in the Senate right now to clear the 60 vote cloture hurdle. But I think it's possible that a future Congress, both houses will vote to remove the deadline, and then it could be added to the Constitution. But I think there would need to be bipartisan support, and that might require a more specific conversation about the relationship of equal rights to abortion. And that's where I also think, I think really right now the sense of urgency is coming from the court interpreting the 14th Amendment through history and tradition in such a manner that suggests in Dobbs that rights that weren't really well established by 1868 should not really be protected if not specifically enumerated. And I think it's not to say that ERA would definitely protect abortion, but would just provide Congress and courts with a more modern source of ideas of gender equality instead of thinking about what gender equality meant, which was nothing. It meant nothing in 1868. And so that's that. With regard to if there were a national ban on abortion, that there have been the so-called partial birth abortion ban. So I think, of course, one of the challenges always to challenging abortion bans is that typically Roe v. Wade was a difficult case because it's always hard to establish standing by pregnant people who are most affected by an abortion ban, whose lives are affected. So I think that always creates a problem, but makes it difficult for courts to bring into very sharp focus all the ways in which women's lives are diminished by certain kinds of abortion restrictions, particularly in states that don't do anything to make it easier to be pregnant or to be a mother. So I don't know. And I think there are many ways in which it might be challenged, although I think the typical pattern has always been that providers are the ones to challenge the bans.
If I could just tie this back to what we were discussing earlier, I think the question is, does Congress have the power under the Commerce Clause to adopt a law prohibiting abortion for the whole country, or adopt a law protecting a right to abortion for the whole country? Were it to be the former, then that would preempt laws like California and New York that allow abortion, In order to be the latter, it would preempt states that prohibit all abortions, like, say, Alabama or West Virginia or Oklahoma. And if Congress either adopts a law protecting a national right to abortion or prohibiting all abortions, it will then be litigated in terms of the scope of Congress's power. My own instinct is that Congress likely has the authority to do either of those things under the Constitution, that the Supreme Court has said that Congress can regulate economic activities that, taken cumulatively, have a substantial effect on interstate commerce. They've defined economic as goods and services that are bought and sold. Abortion is a service that's paid for. Looked at cumulatively across the country, either the existence of abortion rights, denial of abortion rights, certainly has an effect on interstate commerce. And this was the authority that was used by Congress for the law that Julie mentioned, the Federal Partial Birth Abortion Act that was adopted 20 years ago, where Congress prohibited a specific type of abortion procedure. But ultimately, whether Congress can do this with a Democratic president, a Democratic Congress, direct a right to abortion, or a Republican president, or Republican Congress to outlaw abortion, will come down to that question, which would then be litigated.
We got a question about bankruptcy powers and whether state laws can be nullified under federal bankruptcy powers. Our audience member Frank says he remembers a Second Circuit decision in the 70s nullifying a New York criminal law requiring a closed hospital to preserve patient records. And he's never heard mention of federal bankruptcy power in connection with federalism, and wonders if any of you have any thoughts about that.
Congress under the Constitution has the power to create uniform rules with regard to bankruptcy. And where Congress creates such law with regard to bankruptcy, that preempts state law, just like any other federal law does. So as an example of this, a bankruptcy court can grant a stay of any court proceeding, including a state court proceeding, that involves claims by or against the debtor. So if a person files for bankruptcy and they're being sued for an automobile accident in state court, the federal bankruptcy court can stop that state court proceeding. Federalism isn't an obstacle because the federal bankruptcy law authorizes the stay, even in some instances, an automatic stay.
Professor Ross, I wonder if you could speak about, we saw a lot of things after the 2020 election that were startling, right? Pressures on election officials, on state legislatures, on the counting of the votes and all these things. Was there anything that you think can or should be done to try to ensure that the state election apparatus works as it should? I mean, what would you be looking to do realistically to try to make sure that, I mean, it's just such a puzzle. I don't know if what can be done, but you know more about this than most people. So what are your thoughts about how to try to keep the integrity in our election processes?
Right. I guess I'll start with the point that elections as a general matter in the United States function relatively well. And they have functioned relatively well over the last two elections, and especially when you think about the context of the 2020 election in the midst of a pandemic and how well the process ran. There were, of course, a few hiccups around the country, but those are normal for any election. I don't think we're going to get rid of them entirely ever. I think the main problem that we have with our elections is not necessarily to the functioning, although those can always be improved by creating greater transparency, devoting more resources to the process so that the ballot counting process can occur more quickly. There could be more changes in the law such that absentee ballots can be processed before the election, even though they're not counted. They could be, in a sense, open and put in the pile and ready to put in the machine for when the election, for when the polls close. And so it would lead to faster counting of the ballots. But I think that a lot of it has to do with trust, right? And there's a just declining trust in our democratic process and in elections more generally. And that's been, reinforced or generated through, misinformation campaigns. And we are all probably familiar with these campaigns that spread both on media and social media that provide sort of that put forth lies about the election process, whether it be about who's voting or how the votes are counted or how the machines are counting votes. And we saw with Fox News and the Dominion defamation suit that that they were blatant lies and they were reinforced by media that should have been more responsible. So I think that part of it, in terms of thinking about trust, how do you counter trust in a context where there's so much misinformation that's generating distrust? That is a critical puzzle. And I really struggle with thinking about how to do it effectively. But I do think that one way that election officials have tried to counteract it is with greater transparency of the political process. Now you have, when you watch CNN during election nights, you have cameras that are showing what's going on in the vote counting room. You have, partisan actors that are in the vote counting process that are able to contest ballots as they come in. You have systems by which you have, verification of counts. You have some audits in place. Perhaps they could be expanded to more states so that people create a greater sense of confidence in the election process. But then at the end of the day, if that doesn't counteract that misinformation, I don't think that the answer, which has been proposed by some, is to, in a sense, make voting more difficult to enhance integrity, because I think that ultimately gives those who seek to foster this distrust what they want, which is perhaps a less democratic process. At some point, there's only so much you can do to build up the trust in an election process, and I think that the measures that I've suggested could be part of the way. But I don't know if there's anything that could be done to counter the different sources of misinformation about the election process.
I see that Marcy has reappeared. Does that mean, Marcy, that we are done, or do we have time for one more question?
You have time for one more, definitely.
Okay, great. I think the last question I want to take from a member of our audience is about originalism and how originalism, which, Dean, I know you've written and spoken extensively on, interacts with federalism.
Like so many areas of constitutional law, I don't think it's possible to find from originalism an answer with regard to federalism. For example, it was Chief Justice John Marshall in Gibbons versus Ogden who very broadly defined the scope of the commerce power and rejected the idea of the existence of states as a limit upon it. Marshall was at the Constitutional Convention, and we would think he would have a sense of what the original meaning is with regard to federalism. Or take the 11th Amendment. I think the scholarship here is overwhelming that the 11th Amendment was just meant to prevent suits against state governments where the sole basis for jurisdiction was diversity. And yet the Supreme Court, and something that's profoundly non-originalist, has expanded this to say that state governments can't be sued at all in federal or state court. I think what you find here is that the conservative justices have followed conservative ideology and protected federalism, that liberal justices who want to advance individual rights and equality have opposed federalism in the context. But I don't think we're going to find an answer from the framers' intent here any more than any other area.
Well, with that, Marcy, I think we're about out of time. I want to thank our amazing panelists, and I will turn it over to Marcy for final remarks.
Thank you, Jen, for doing such an excellent job of moving the discussion so smoothly. And on behalf of the Rule of Law Task Force and the City Bar and our co-sponsors, I want to thank our speakers, Dean Erwin Chemerinsky, Professor Bertrand Ross, and Professor Julie Suk, for sharing their illuminating insights with us this evening in this discussion, which I can only characterize as extraordinary. I want to thank our audience, too, for spending part of your evening with us. This program has been recorded and will soon be available on the nycbar.org website on the Rule of Law Task Force page. You will also find materials on our series there, including articles written by our speakers, which offer more detail than time permits in our webinar sessions. Please let your colleagues know about our posting. Apparently, as we can see from this evening and the questions here, and appropriately, I would say, there is great interest in these issues. So I'm delighted to tell you that our next program in this series of virtual programs will be presented on May 17th from 6:30 to 8:30 p.m. And will address interstate and regulatory clashes, commerce, preemption, and the corporate law. It will be followed by our session on May 24th from 6 to 8 p.m. to 6 to 8:30 p.m., sorry, on abortion and the chaos of conflicting mandates, where we will get into a number of the questions that we didn't have time to address this evening. And the final session will be offered on June 8th from 6 to 8 p.m. on guns, the environment, and navigating the red-blue divide in America. You can register for each of these future sessions now on the City Bar's website at nycbar.org. Each of these sessions will feature thought leaders in each of these subject areas, and each one of them promises to be every bit as stimulating and thought-provoking as this evening's presentation. Please let your colleagues know about them and make plans to tune in. Thank you all, and good night.